Public Protector Advocate Bosasa Mkhwebane was dealt another blow by the Constitutional Court. The Apex Court ruled that Mkhwebane was wrong on the facts and the law that President Ramaphosa misled Parliament.
I therefore find that the President's failure to disclose financial interests which accrued to him as a result of the donations received towards the CR17 to be in violation of paragraph 2 of the Executive Ethics Code and accordingly amounts to a conduct that is inconsistent with his office as a member of Cabinet.
Justice Jafta says the manner in which the Public Protector framed her findings are concerning.
The Public Protector was wrong to change the code. She could not have conceivably thought that willfully could mean inadvertently. These words are mutually exclusive. What she did went beyond the parameters of interpretation, but the finding itself is framed in terms that are concerning. The President could not inadvertently and deliberately mislead Parliament because these two words cannot apply at the same time. It is either one or the other. Therefore, the Public Protector was wrong on the facts and on the law with regard to the issue whether the President had willfully misled Parliament, and the High Court was right to set aside her finding.
The Constitutional Court went further to state that there was no evidence pointing to President Ramaphosa benefiting directly from the CR17 funds.
There was not a shred of evidence that African Global Operations or the President and his son had anything to do with the operation of that account. Instead, the evidence on record is to the effect that the President had no say and was not involved in the running of that account. This evidence was not disputed. Therefore, on this evidence, the President was not involved in the payments made from the EFG2 account to the foundation carrying the President's name. The evidence on record showed that the President did not personally benefit from the donations made to the CR17 campaign.
The Apex Court also says the Public Protector had no legal basis and powers to investigate private affairs of intra-party political funding campaigns.
But more importantly, both these issues did not form part of any of the complaints submitted to the Public Protector. Therefore, she did not have the authority to investigate matters falling outside the complaints. This is a requirement of Sections 3 and 4 of the Act that empowers the Public Protector to investigate violations of the Code.
The Constitutional Court has upheld the High Court judgment setting aside the Public Protector's report. But the case of Ramaphosa goes back to the High Court on the Code of Ethics Act on the disclosure of intra-party political funding campaigns being declared.
Leave to appeal is granted. 2. Save to the extent mentioned below, the appeal is dismissed. 3. The dismissal of Ramaphosa's Center for Investigative Journalism NPC's claim for constitutional invalidity of the Executive Ethics Code is set aside.
The Public Protector Office says Advocate Bosasa Mkhwebane will study the judgment and learn from it.
I hand down the judgment.
Samkele Masego, SABC News, Johannesburg.